You're making trademark mistakes that are setting you up for an expensive rebrand later. You've probably heard things like just throw a TM symbol next to your name and you're good, or I don't need to trademark anything until I'm making more money, or my personal favorite, I registered an LLC so I own the name. If you've heard one or all of these, don't worry, you're not alone. As a trademark attorney, I hear them all the time from business owners. But some of these myths can cost you a lot of time, money, and in some cases, your entire brand. So in this video, we're busting the most common trademark myths that get people in trouble. So the first myth is I have a domain or IG handle, I own the name. Let's say you come up with a name you love. It's available on Instagram. You grab the .com domain. Maybe you even start building your brand around it. And most people think I'm good now. I've claimed it, but unfortunately, legally, you haven't. Having the domain or the handle means you control that specific space online, but it does not mean that you have the exclusive right to use that name in commerce. Only a trademark gives you that protection. And I know this from experience. I've had people come to me after months, sometimes years of building their brand with the name they thought was safe, only to get a cease and desist letter because someone actually trademarked it before them. And the person who owns the trademark doesn't have to have the domain or the Instagram, but they still have the power to stop you from using the name because they legally own the trademark. So trademarks protect your name in connection with specific goods or services. Domains and Instagram handles, not so much. They just make you findable, but they don't actually protect your brand. Now, before we move on to the second myth, if this has you thinking, okay, maybe it's time to talk to somebody about this, book a call with my law firm so we can have a more in-depth conversation about trademarking for your business. And you can grab a spot using the link below in the description box. So myth number 2 is I don't need to trademark anything until I'm making money. This one makes sense at first. You're just starting out, trying to be strategic with money, and you think, why file a trademark when I don't even know if this idea will stick? And I get that, but waiting too long is how a lot of business owners end up losing the name that they've been building. In the US, trademark rights are based on priority use, not just who made the most sales or who had the idea first. So if someone else is already using the name and they file before you do, they may have stronger rights to it, even if you've been using it. And even if they've been using it after you're going to have to go through either a cancellation or opposition if they have filed for registration. And that is very expensive. It's basically you litigating. And if you don't have the funds for that, you're going to be forced to rebrand. So a real world example of, filing a trademark but not being able to get the name is Meghan Markle's American Riviera Orchard brand. So when she filed the application, this name ran into trademark issues immediately. They deemed it geographically descriptive due to American Riviera, and the application was rejected. And even with her legal team and a big budget, she still had to change direction, which is when she pivoted to As Ever. So imagine what happens to small business owners who have way fewer resources when they wait and run into that kind of problem. And I've seen way too often people will launch under a name, make sales, grow an audience, and then someone else files first. And that person then legally owns the name. And suddenly, again, you're in rebrand mode, whether you like it or not. And rebranding is not just swapping out your logo. You have to change your packaging, your socials, SEO, your emails. It's a whole thing. And that's why I always recommend filing as early as you can when your business's vision is clear. And if you're not quite live yet, you can file an intent to use application that basically lets you say, hey, I'm planning to use this name, please hold my spot. And once you start using the name, you'll update the application to complete the trademark process. Now, let's talk about myth number 3, which is putting the TM trademark symbol next to my trademark protects me. TM doesn't actually protect you the way people think it does. So the TM symbol just means you're claiming something as a trademark. That's it. There's no review process. There's no legal protection automatically granted. It's basically like a public signal that you believe this name represents your brand. But what it doesn't do is it doesn't stop someone else from filing the official trademark. It doesn't give you exclusive rights, and it doesn't give you much leverage if you ever need to challenge someone for using your name. Now, the registered trademark symbol is different. You can only use the registered symbol after your trademark is officially registered with the USPTO. And adding that registered symbol before you're approved, that can get you into trouble because it is illegal to use it prematurely. And I have seen people confidently put that TM symbol on their brand thinking they're protected, only to get a letter in the mail from someone who actually owns the trademark. And this is such a rude awakening and really heartbreaking, especially after you've built something so meaningful. Now, myth number 4, my LLC protects my name. This trips up a lot of people, especially when you're going through the effort in forming your LLC, paying the fee, and getting the official paperwork from your state. It feels like a big deal, and it is, but the problem is your LLC only protects your business name within your state, and only as a business entity, not as a brand. So let's say you register Glow Up Studio LLC in Florida, and then someone in California might already own that trademark for Glow Up Studio, and they've registered it with the USPTO. Now, even though your LLC is legit in Florida, you don't own the name on the national level, and that other business can send you a cease and desist letter. And this is what you should remember. Your LLC protects you and your personal assets. Your trademark protects your brand. They do two totally different jobs. Now, myth number 5 is something I see way too often, and that is I changed the spelling of my trademark so it's different now. This one is sneaky because it feels clever. You find a brand name you like, it's already taken, so you think, no problem, I'll just change the spelling. Maybe you swap an S for a Z, or you take out some vowels and boom, like it's unique now, right? That's not exactly true. Trademark law doesn't just look at how a name is spelled, it looks at how it sounds, how it looks, and how likely it is to confuse someone. So even if the spelling is different, if it sounds the same or gives off the same impression, it still might be considered infringement. For example, say there's a brand called Boss Babe, and someone else tries to register Boss Babe spelled B-A-E-B, the other one is B-A-B-E. Same, they both sound the exact same, and that would easily be rejected by the USPTO, or even worse, get you a cease and desist from the first Boss Babe that has already trademarked it. And I've had to tell clients, I know it looks different, but it's still too close, and that's hard to hear when you've already started building something around that name. And this is also why people get confused when their application gets denied, and they're like, I made it different. The USPTO is looking for likelihood of confusion among consumers, and if they determine it to be so, then your application will get rejected. Now, myth number 6 is I trademarked it first, so now I'm good. There's something really satisfying about seeing that your trademark got approved. I know I'm so satisfied for my clients when I see that registration come through, because you have filed, you have waited at least a year, and now it's yours. And so you probably think it's safe, and that's not always the case. In the US, like I said before, trademark rights are based on priority use. That means someone who was using the name before you, even if they don't register it, might have stronger rights in certain situations. So just because your trademark was approved, that does not mean it cannot be challenged, especially in that first 5 years after registration. Someone with legitimate prior use can petition to cancel your trademark. And this is something I think a lot of small business owners don't even realize, they don't know, and it is a hard lesson to learn, because now you spent time and money getting it registered, and someone can come in and try to take it away. So yes, filing early is a smart move, but please don't skip the research. A proper search before you file is what helps protect you after you file. The goal isn't just to get approved, it's to keep the name long term. And if you need help with the search, I do those as well, and I will link that in the description box too. Now, on to the last myth, myth number 7, one trademark covers everything I do. And this one, again, is something that I see all the time, and it feels like it should be true. I mean, you have gone through the process, you've registered your name, and you're like, okay, great, I'm covered. But the truth is, trademarks don't work like a one-size-fits-all blanket. They only protect you in the categories or classes you registered under. So let's say you trademark your brand for coaching services. That does not mean you're automatically protected if you launch a product line or a podcast or like a candle line, because those are different trademark classes. And what trips people up is you can have 2 companies with the exact same name operating legally because they're in different industries or classes. So think of Delta Airlines and Delta Faucets. Same exact name, totally different markets, and the USPTO does not consider that confusing. But if you're expanding your brand, let's say you start as a coach, you later add merchandise or a podcast, these could fall into completely different classes. And if you didn't include them in your original application, you may not be protected there. So this doesn't mean you have to trademark everything up front, but it does mean you need to be strategic. So as your brand grows, revisit your registration and make sure your protection grows with you. You can file a trademark application later to cover those other products or services that you're selling, as long as they're available, of course. You'll have to do all that research all over again. So if you're someone who wants to learn even more about trademarks, make sure you watch my next video where I'll cover what happens when your trademark is taken. And don't forget to like, comment, and subscribe.